Welcome back to another episode of the Collaborative IEP Podcast. I'm Ashley Burlow, your host, and I am so happy you are here. Boy, are we ever chugging right along after several weeks of living inside section 1414. It took us 5 tries to get through that section, 5 different parts to get through that section. We are landing in section 1415, which has to do with procedural safeguards. This is obviously a really huge piece of idea and something where attorneys and advocates spend a whole lot of time, because basically what procedural safeguards do is give a bunch of rights to parents. And I think that's really exciting. So I want to take a second and talk about why that's exciting. And here's the way that I say it a lot. So, and I probably said this, like we did like an episode on procedural safeguards really early in the podcast. I don't know how long you've been here and how far back you've gone, but I probably said this in that episode as well. So, when I first started practicing law, I was in a general practice. I did a lot of divorce work. I did civil work, like car accidents and, which is called personal injury. I did general civil. Like for a while, I had a bunch of landslide cases, which I really did not want to do, but I had a good settlement in one, and then I got a bunch of referrals for those. And, slowly I kind of whittled my practice down and hilariously, just as an aside, decided not to do anything else that was in the executive branch, like administrative laws, because they're so nuanced. And then this like ginormous wave of special education cases came. And I had this experience where I was like, you know what, we're going to dive into special ed. And here we are now practicing exclusively in special education and special needs estate planning. Anyway, that's a long way around to say I used to do a lot of divorce work. My practice always focused on special education and family law matters. And in divorce work, I would have people come to me all the time and say, well, I've got a right to see my kids, or I've got a right to parent my kids, or I've got a right to whatever. I've got a right to this, to something relative to my kids. And I would tell them, the best interest standards in the state of Kentucky is based on, I think it's 11 different criteria. And one of those one criterion of those criteria is the desires of the parent. 1 out of 11. Now, they aren't weighed all equally. The child's desires get, relative to any decision, get more weight in Kentucky as you age, according to case law, if you really look at case law. But it's really nuanced because all families are dynamically, beautifully nuanced. And still, of 11 criteria, the parents' desires are 1/11th, I think, statutorily. And don't quote me on that, but like the concept remains the same no matter what the denominator is. So, my point there is parents don't necessarily have a ton of rights relative to their children in family court matters. And you'll hear commercials all the time. We're protecting men's rights, or we're protecting women's rights, and the mother has rights. And there's like this whole body of law about grandparent rights. And truly, when it all boils down, the adults don't have a whole lot of rights. In fact, the standards in most states are called the best interest standards, and we're just making decisions in the best interest of the child. Now, come back over here to the administrative sector and special education, and here's what's exciting. Parents in special education have rights. In fact, there's an entire section of the law about procedural safeguards, which could just be renamed parent rights. And the reason why, and this is super duper important, the reason why is the Congress acknowledged that parents have a very unequal playing field as compared to the school in special education matters, right? School professionals are trained. Schools have better resources. They can pre-plan for attorneys and for administrators that are in charge of special education. Schools have the advantage in very many of the components of special education: planning, implementation, communication, et cetera, et cetera, et cetera. And so that's the kind of exciting component of this is Congress said, we need to level the playing field for parents, and we need to give them these procedural safeguards. I think it's super exciting. We're going to dive in here with section 1415 in just a second. Before we do that, though, I want to talk to you about something that's super exciting. This is the way that I'm spending the rest of my day. I have a couple of meetings, and then all of my extra time is spent on building out this summer and fall of 2025 project. So I have beta tested this project with a smaller group of people this year, and it has worked out really, really beautifully. And I'm really excited to talk to you about it. Both in my law firm and at the advocacy business, I am going to start marketing to everyone and availing to everyone a retainer fee agreement whereby my clients, both advocacy clients and legal clients, hop on a call with me, Zoom if you prefer, where we go through monthly meetings, just 1 hour down and dirty, get to the nitty gritty problem solving meetings once a month for 9 months, preferably during the school year. So in a lot of places that is September through May. And then we take June, July, and August off. Some school years are shifted 4 to 6 weeks, and we can be flexible. And if you want to start in December, great. You just pay for a year and we take the summer months off. But in those meetings, what I have been doing with about 8 clients this year is we have been going through progress reporting notes, and I will help with communication about progress reporting. We've been going through, like, some of them are DIYing significant advocacy issues. Like, I want this particular reading program, or I don't want this particular reading program. And so we'll get together once a month and the clients will say, we said this, the district said this, we gave them this documentation, this was their response. And then I help to curate the next response and help them to kind of DIY it. We've gone through how outside data impact special education and how to communicate about that. I've helped clients prepare for their annual meetings, for evaluations, for meetings with experts or other professionals that they can bring in, et cetera, et cetera, et cetera. Then, and what happens is I do that at a discount, a 20% discount on my regular billing rate. Okay. So you get a discount if you subscribe to this. And then if clients need me for additional matters, whether it's attending a meeting or doing a file review or, writing emails or demand letters or writing complaints, whatever it is, or hopping in and being the face of their advocacy, I offer that at that continued 20% discount. And here's the kind of exciting thing is what we're finding is that it is a lot less expensive because I'm in their files and I know their cases far more intimately. And so I don't have as big of like a learning curve when I hop in and I become the face of the advocacy. So it has worked out really, really beautifully. I would suspect I haven't gotten commitments from everybody. I'm like, I don't want to sound salesy, right? But I would suspect that the large majority, if not every one of my current retainer clients will stay on for next year because it's worked out really well and the value has been really good for them. And so I'm going to offer that to everybody. For right now, if you are interested, go ahead and just shoot me an email or DM me on social media. I'm interested in the retainer fee agreement, and we can chat and figure out what works best for your family. And then for those clients this summer, and if you're interested in this, I can do that as well for you. I am going to be curating some summer work for those clients. So I'm going on Teachers Pay Teachers. I'm to a certain extent, maybe even creating some of my own materials for folks. And then the big advantage is I'm giving it to families and saying, here's how you should work with your child on these things. And here's how you can monitor progress in a really kind of like low impact way, not a whole lot of work on you. And then we'll use that to write really good communication at the beginning of the year to kind of support whatever it is that we're looking for. So, if we're looking for a particular reading program, then I'm going to curate summer work for you to work with your child, or a tutor or a babysitter to work with your child, and to keep certain data so that then we can communicate that over to support your arguments and discussions about that particular reading program. Okay. So Rachel was like, my first attempt at writing this up was actually too short, if you can believe it. And I was like, I know it needs so many words to describe it. I'm just going to talk about it on the podcast. And I'm sorry, that actually did take 5 minutes. So now today's challenge is figuring out how to write that. Okay. So back into IDEA, I got a new computer, I got a new printer, and which is always fun, the joys of small business ownership. If you have taken the ABC course, you hear me lament about this a lot. But anyway, I just went ahead and printed off the printable view of IDEA, and we are more than halfway through Part B. So while it took us forever to get through Section 1414, 5 different episodes to be exact, we are more than halfway through IDEA Part B, which is exciting because that's where the K to 12 stuff lies. So now we are in section 1415, and just as always the case, we went to get our bearings in section 1415. As we always do, what we're going to do is we're going to go through the sections and see if we can figure out where we are. So just like any other part of IDEA, our main sections are lowercase letters, and they are encapsulated by parentheses. I won't sing you the punctuation song, but you know, I love you, period. Do you love me? Question mark. Please, please, exclamation point. I want to hold you in parentheses. Told you I wouldn't sing, but I can't start it without getting to the parentheses joke. Okay, so we have A through O. Oh my gosh, we've got a lot of different sections. We will quickly fly through those titles just so that you get a lay of the land before we dive into subset A, which is pretty easy. So A is called establishment of procedures. B is called types of procedures. Yes, in subsection B, we get a lot of those procedural safeguards. C is notification requirements. D is procedural safeguards notice. So we're going to be talking about what kind of notice they give you. E is mediation, one of my favorite things to talk about. F is impartial due process hearing. So yes, in this section, we're going to be talking a fair amount about due process. G is appeal. Can you appeal that due process impartial hearing? H is safeguards. So we've got procedures and there's safeguards. So we're going to talk about what procedural safeguard actually means. I is called administrative procedures. J, we are getting to maintenance of current educational placement. That's our stay put thing that we're going to talk about. K is placement in an alternative education setting. And another reason why we like to get a lay of the land is because I just passed K, and if I didn't go from J to K, I would lose it, right? And so it's important that we get this lay of the land so that we don't lose sections. And that's really easy to do if you just start in reading. K, I think I didn't lose K, I said it, but my brain lost it. And still, it's important to go back and make sure that you are keeping up with what you're reading for the context. K is placement in alternative education setting. And now I am looking for L, which is always hard to find because it looks like a 1. L is called rule of construction. I'll explain that. It's pretty legal. M is transfer of parental rights at the age of majority. What happens when you turn 18 or you're otherwise capable of making your own decision. N is electronic mail, keeping up with the times, our federal government. And O is a separate complaint. Let's get moving. We're going to dive into section 1415 of IDEA. Quickly before that, let's take our first break.
Hi, friends. It's Ashley, and I wanted to let you in on something that can seriously change the game when it comes to your IEP advocacy. It's called the Collaborative IEP membership. Sometimes we call it ABC Club. And it's packed with resources to make your IEP meetings easier, less stressful, and way more effective. Here's what you get. My complete IEP binder. This baby includes monthly drops of communication templates, guides, and checklists to keep you organized and on top of things. Access to our full inclusion workshop, behavior workshop, and negotiation workshops. These are deep dives that give you real strategies you can actually use. And with the membership, you get all of our IEP Guru Academy videos. Short, practical videos that will answer the exact questions you're asking right now. Every month, we'll also drop new content like how to navigate PDA with your neurodivergent child, or exactly how to ask for Orton Gillingham reading instruction, so you're never left guessing. The membership is $29 a month or $297 for the entire year, and you can try it risk-free with a 3-day trial. Head over to the website, thecollaborativeiep.com/membership, and join us today. Let's make your next IEP meeting your best one yet.
Okay, so A is pretty easy. It just says that states and local education agencies need to establish procedures that ensure the rights of parents that are consistent with this law. So that means that they can do more, or they can just at least follow 1415. Obviously, they can't trump federal law. B, types of procedures. So now is when we start to get into those procedural safeguards. And I will tell you that if you are to read Section 1414B to learn more about procedural safeguards, a lot of them are hidden within other provisions. And I believe this is why when you see people write out lists of procedural safeguards, why there's like not a specific number that anybody quotes. It's because there are so many different things within B. So B goes 1 through 8, but within those 8, I would not say that there are 8 procedural safeguards. There are more because there are several that are listed inside the different sections, and that's confusing. And that's probably why it is important to listen to attorneys that are breaking this down for you, or to read books or whatever. Okay. But like, stop and pat yourself on the back for taking the time to listen to me go through it. I'll try to muddle through as efficiently but helpfully as possible. So it just starts off and it says the procedures required by this section shall include the following. Okay. And then it goes 1 through 8. But again, we're going to get more procedures as we go through. Right. So, and then remember, we talk about safeguards in a second. So then we'll circle back and we'll talk about the difference between procedures and safeguards and what procedural safeguards then are. So, procedures, an opportunity for parents to examine all records relating to the child and to participate in meetings that involve the following topics: identification of the child, evaluation of the child, and educational placement of the child. And then, and number 4, the provision of a FAPE to the child. So parents get to participate in meetings about those 4 topics, which obviously all IEP meetings are, because we're always talking about those topics. And then the third thing is to obtain an independent educational evaluation of the child. So within number 1, we already got 3 procedural safeguards. So an opportunity to examine records, you can simply say under Section 1414, subsection E1, I'm requesting the opportunity to examine the records of my child. Some states require that those are free. Some states allow school districts to charge you, but you can at least go look at them for free under IDEA Section 1414B1. Then number 2 is to participate in meetings, which we know parents have the right to participate in meetings. I can't imagine that there would be a meeting that would be called that wouldn't fall under one of these 4 different categories, but maybe that has happened. I've never had to look that up. I've never had a parent excluded from a meeting on purpose. And then number 3 is the opportunity for an individual education evaluation. We call those IEEs. Basically, if you disagree with the school's evaluation, and we talked about this when we did evaluations, but if you disagree with the school's evaluation for any reason, you can request your own evaluation, which again levels the playing field, and the school has to pay for it. Okay, so those are 3. Now we get 2A and 2B. So 2A is that parents are entitled to procedures to protect the rights of the child if the parents are not known and the school can't find the parents, right? So maybe the child is in foster care, maybe the child is in the care and custody of a loved one, maybe the parents just have never shown up. And so and the statute references this. Sometimes they appoint what's known as a surrogate. So a surrogate is a person that comes in typically for children that are wards of the state or in foster care or otherwise in the care of the state, but it could be that they're in care of another guardian, and that person serves the parent's role on the IEP team. I have a lot of advocates that have taken the ABC course that will become surrogates for their district. because it's really good practice. It's really interesting work. It's obviously very noble work because you're working for some of the most vulnerable children in your district, and it's really rewarding as well. So if you are a newer advocate, that is definitely something that is available to you. So that is 2A. And then 2B gives us when those surrogates should be designated. So within 30 days, blah, blah, blah. Okay. So that is subsection 2. And then subsection 3 is about prior written notice. Now, here's one fun fact and idea. You've heard about prior written notice 100 times. You've seen it abbreviated PWN, and you're like, what the heck is prior written notice? I remember when I called an advocate relative to my child when we were doing our kindergarten. I like to call it a discussion. For 9 months, I finally was like, okay, this is not working. I cannot be objective about my own child. Remember, people do as I say, not as I do. I called an advocate and she said, well, have you gotten your PW? Well, actually, she probably called it a PRO1 because that's what they call it in Ohio. That's the form. And she was mainly in Ohio. So maybe that's why it confused me now that I think about it. But I think she might have said PWN. And I felt completely inadequate because I did not know what that acronym was. I was not as ingrained in this work at that time. And I was like, what is that? And she was like, oh, your prior written notice. And I was like, oh, yes, I do have a prior written notice. In Kentucky, they're called conference summaries. And I do have that, and it's well documented. So no, they did not violate my procedural rights relative to writing that down. But I remember feeling completely inadequate. And here's the fun fact. It's actually called written prior notice, not prior written notice. I don't know what makes more sense. I haven't spent a whole lot of time thinking about it. But if you wake up tonight at 4:00 in the morning, you can decide if you prefer prior written notice or if you prefer written prior notice. At any rate, what it means is that before they do certain things, the school has to notify you, and that notification has to be in writing. Okay. So you are entitled, parents, to prior written notice or written prior notice if your school district, A, proposes to initiate or change, or B, refuses to initiate or change if you request it, right? So if they proactively or reactively don't change or start identification, evaluation, or placement of the child, or FAPE, if they don't provide a FAPE. So let's break this down a little bit. So this is kind of a tip for reading a law. Proposes to initiate or change or refuses to initiate or change. We're just going to take one of those clauses. So if the school proposes to initiate the identification, if a school proposes to initiate the evaluation of a child, if a school proposes to initiate educational placement of a child, if a school proposes to initiate the provision of a FAPE, hey, we want to start special education services, they have to give you notice of that fact before the fact in writing. Same thing with changing. If they want to change the placement, if they want to change the provision of FAPE, the way that they say they are providing FAPE, they have to provide that in writing. Now, the IEP document is in writing, but certainly you have to get some kind of provision in writing in the meeting minutes and the conference summary and the PRO1, whatever they call it. Okay, so that is number 3. Moving on to number 4. Okay, subsection 4 allows for procedures that are designed to ensure that the notice is in your native language. So not only does it have to come in your native language, but they have to make procedures relative to giving that notice in your native language, which ups the ante just a little bit. Now, there is a feasibility thing here. So if it isn't feasible, then they don't have to do so. Number 5 is the opportunity for mediation, and we get more information about mediation in a second. And number 6 is an opportunity to present a complaint. This is about state complaints. So the opportunity to present a complaint, A, we get an A and a B. A, with respect to any matter relating to identification, evaluation, educational placement, or a FAPE, those 4 things again. And B, an opportunity to present a complaint which sets forth an alleged violation that occurs not more than 2 years. So we've got the statute of limitation before the date that the parent knew or should have known about the violation. Now, remember, this is our procedural section. So if we go back a second, we are in section 1414B, types of procedures. So this is why we say that we can file state complaints relative to procedures. And, a lot of times we say state complaints are about procedures and due process complaints are about FAPE. But you will see that we have FAPE mentioned here. So let's dive into that just a second more because I think this is important. So you can present a state complaint. Parents can file state complaints. I'm just going to read the part about FAPE. With respect to any matter relating to the provision of a free, appropriate public education to a child. So basically, state complaints, if we look at FAPE alone, are relative to the procedures involved in providing the FAPE, like they didn't do something or they did do something. And due process complaints are about the denial of FAPE itself. We did get a FAPE and therefore we have failed to make progress. We have failed to access education in that way. Let's keep going because I hope we can finish 7 and 8 in this episode, and then we will leave off at section 1415C for next week. Okay, so parents are also entitled under subsection 7 to procedures that require either party or the attorney representing either party, so either the school or the parent, to provide a due process complaint, which we're going to get to here in a second, but they do have a few subsections of that. We'll revisit that when we get to due process complaints later on in this section. And then 8 is procedures that require the state, so like the Kentucky Department of Ed or the Oklahoma Department of Ed, to develop a model form to assist parents in filing complaints and due process complaints. And so that's why you can always look on your state's website for those complaint forms. Okay, that is a parent right that you have. So I think that's a great place to stop. We're trying to keep these relatively short so that we can, really kind of hone in on the details and I'm not overwhelming you. We will come back next week to section 1415, subsection C, and hopefully we can get through a few more sections. I will see you next week, same time, same place.